All right, we're going to do concur, not concurs first, and we'll start off. I think both these are Jamie's, are they? Or they're not?
SB 763, Jamie.
Yeah.
So Senate Bill 763, this was the public safety and criminal procedure collection, reporting, and publication of criminal case and prosecutorial information. This was the parenthetical on this was the Maryland Criminal Justice Data Transparency Act. It was one of the bills that the committee had worked a number of provisions into. And for 763, just make sure I've got it. I had them, let's see. Give it to Josh since this was actually a Josh bill.
Yeah, so as passed by the Senate, the bill requires the Sentencing Commission, with the cooperation of each state's attorney, to collect and disclose information on criminal cases in the circuit court. And the bill also required the Division of Parole and Probation to annually report on individuals under its supervision involved in specified crimes, and made a definitional change to allow DPSCS to share criminal justice data. So the House amendments do a number of things. So first, they strike all of the provisions in the bill requiring collection and disclosure of case information, and instead establish a task force to study the issue. They strike the definitional change in the bill. And finally, the House amendments add the contents of 3 different Senate bills to the bill. The first one being Senate Bill 392, which is the Judicial Transparency Act, except that the House amendments make a change to that, which requires that information be collected by judicial circuit rather than by county. The second bill added is Senate Bill 389, which makes some changes to the police disciplinary process, except that the House bill does not include a provision in the Senate bill which delayed the effective date of some provisions from last year's police reform bill. And finally, the third bill added is Senate Bill 896, which makes some modifications to the Independent Investigations Unit in the Attorney General's office, except that the House version of the bill does not include a provision which was in the Senate bill, which gave the unit the first opportunity to prosecute a case.
All right, so I suspect, look, the certain members won't like the new scheme for the circuit versus county reporting data because it's less granular, less close. We don't have this in writing. I know and I suspect some people will like the fact that for the independent investigation of the IAD there's no longer the prosecutorial authority. That's stripped out. They just kept the other 3 elements that were in the bill, which is the subpoena power. What else is it? Subpoena power. It was the clarification that the investigative authority rests with the IID, right? They probably kept the name change, and there's a third part. What was the third part? Was that yours initially?
For the IID?
Yeah. It's my bill, so I should remember. But anyway, they took out the most offensive part in terms of that some people consider the most offensive part, which is the prosecutorial authority. And then we delayed the implementation date 3 months because we corrected the internal, external reporting, and then also the trial board process. And then we added a state-level process for complaints for the Maryland State Police. Do you remember we did that? So they pushed back the implementation date to the initial implementation date of House Bill 670 from last year. So that 3 months, in my estimation, is pretty critical. I know that the counties have been calling in from across the state asking for more time because now we're changing what they have to promulgate regulations for They do need more time, and they are working in earnest. I mean, I know that there's some skepticism there, but I've talked to the MPTSC and a number of other folks that are associated with developing the regulations, and they're working in earnest. Like, they're not playing games. They're not used to doing this at this scale, and we've thrown a lot on them. So also the counties are up against it because they have to have this framework in place by the effective date of the bill. How do you do that without regulations first? So it's a very tough situation. You really do need to push back that implementation date. I know it's not, what?
I was just going to say that they had indicated that there were certain things from 670 that they were unclear on, that this
Yeah.
bill adds clarity to.
Yeah, I mean, exactly right. I mean, the point of that portion of this bill, which is like now this multi-pronged bill, was to ensure that there was clarification for a lot of the elements of 670 to include that trial board process and the complaint process. So, let's go ahead and talk it over. I would say not concur, and we can talk about this stuff, but do you want to just read one more time the differences between and what they've slid in? Because they've created a completely new bill now, so.
Right. So the House struck all of the provisions which required the collection and disclosure of case information from the state's attorneys, and instead there's a task force to study the issue. And then the House added the contents of three different Senate bills with some changes. So first, Senate Bill 392, the Judicial Transparency Act, and they changed it to require information to be collected at the level of judicial circuit rather than by county. Senate Bill 389, which was the bill making some changes to the House Bill 670 of last year. The Senate version pushed back some of those provisions in House Bill 670. The House bill does not include that delay of the effective dates. And finally, Senate Bill 896, which is the bill modifying the Independent Investigations Unit in the Attorney General's office. And the change there is that the House version strikes out the provision which gives the unit the first opportunity to prosecute a case over the state's attorney.
Just to be clear, though, there is no opportunity at all, not just first, in this version, right? Because it's not like there's a declination language there for the state's attorney, and then, a certain time afterwards, the Attorney General has the ability to. I think it's a closed door. The Attorney General is no longer involved at all in the prosecution.
I believe so. Jamie may have to confirm, but they struck the entire section of that bill out.
Yeah, so, I mean, just the way to say it would be not first, just any. They're not involved.
Takes it, they're done.
Correct, just like it is now, normal, like.
So the Attorney General does the investigation, that's the end.
So it essentially keeps the system the same, save for a couple things. It gives the investigative unit subpoena power instead of having to convene a grand jury, which is most, I think, acute with the smaller jurisdictions where it's hard to convene a grand jury and it delays. So I think they're always going to get the subpoena through the grand jury anyway. It just takes time. So, and then there's some clarifying language there that just says, look, this is no kidding. The investigation piece is under the purview of the Attorney General, because there's been some gray area, not so gray area. It was clearly the intent of the legislature to make the case, but it clarifies that. And then there's a third piece that I keep forgetting. So I guess
But that's it, there's no authority of the Attorney General to prosecute the cases.
that's correct.
Okay, so just to investigate, not to
Correct.
prosecute. Okay.
Take them in order. So subpoena authority, this is subpoena authority simply for that independent investigations division, not AG writ large, it's just for.
Understood. That's very good clarification. Yes, correct.
Okay, all right. And then the second is the, you say that the Attorney General, the IA, Internal Investigations, is totally under the AG. I'm sorry, was somebody disputing this, under the AG? I'm not sure what you're referring to there.
I'm sorry. Say it one more
I
time.
thought you said that it clarifies that that division is
Oh,
totally under the
no.
AG.
Just that responsibility for investigation. So that injunctive relief, remember that piece that it talks about, hey, like, that is essentially a tool that we're giving them to say, look, if there's a jurisdiction that's moving forward with a parallel investigation, it's the ability for the IID to say, look, this is our show.
Okay, but I thought you just said in the predicate of this was that it returns the prosecution to the county, the state's attorneys, and not to the.
That's correct. So this
like
doesn't
your
deal anything
ecosystem.
with the prosecution piece anymore. So the way it came back, there's no prosecutorial authority for the Attorney General.
So what's he doing? Is he the lead investigator
It's
still, or-
basically the same as under House Bill 600 Senate Bill 600 last time, just the investigations.
So it's saying that they are the police-involved incidents, but their role is the same under this as it is currently, which is that they, after completing the investigation, they provide a report. So, right, it takes away the prosecutorial authority, that stays with the state's attorneys, but as it is currently, after they finish the investigation, they provide the state's attorneys with that confidential report.
The criminal side's gonna subpoena that for trial and find out
100%.
what the Attorney General has said, and then use that to cross-examine, right?
Well,
I mean, that was a big.
I mean, it's, let's see, within 15 days after completing an investigation required under subsection C of this section, the independent investigative division shall transmit a report containing detailed investigative findings to the state's attorney in the county that has jurisdiction to prosecute the matter, except as otherwise provided by law. The report under this subsection shall remain confidential.
For 90 days, right?
Let's see, shall remain confidential through adjudication of any associated criminal case at the trial court level. So that's in there, and that's,
So the person
existing.
responsible for prosecuting wouldn't be the lead investigator. That's pretty bizarre, isn't it?
Well, that's what we passed last year.
But we didn't quite say that language, though. We still had well, that was that whole dispute, right? Is who has what. So this is,
I was trying not to get into the Sheriff Gaylor thing.
yeah, but that's all this is about. We're mucking this up. Oh, my God. This is a who's his bigger battle. That's pretty sad. Because nobody ever said they couldn't come in and investigate. All right, so we have that piece, and then we're saying that on the judicial transparency, instead of it being by county, it's by judicial, so there's what, I don't know, 9 judicial circuits or something like that? So 8 or 9 judicial circuits, so that data becomes pretty much worthless. And then oh, God.
So there, what's the other piece? So Judicial Circuit, IID, and,
Then there's the police disciplinary.
oh, the implementation deadline.
And we pushing that
so
back
you
or
guys-
bringing it back forward again?
You guys had pushed it to October.
Right.
They put it back to July.
So-
Yeah, we have to not concur. I mean,
Look, I know that
it
here's,
seems like you ought to stand I know where you're coming from. It seems like we ought to really stand our ground on that date.
oh, I understand, I 100% agree with you. It's politically inconvenient, but it's the right thing to do. We've added so much new stuff for them to do.
There's 3 things.
Yeah, yeah.
You can go to conference and say, we'll give you 2, you
Yeah.
can give us 1, right?
Yeah, yes, exactly right. So the motion would be not to concur. Senator Bailey, real quick, go ahead.
So is it possible to do just that? I mean, these concurrents are rather new to me, and Senator and I were just discussing it. I mean, a couple of them sort of make sense, but a couple of them, one of them makes no sense.
Could agree on, at least I'll say this, I mean, I know a lot of people can't say this out loud, but I'm not gonna speak for anyone else, but the implementation thing is politically tough for some of us, but it is absolutely the right thing to do. You can't have completely new framework set in place and give no one time to do it. I mean, it would just,
The bill changes it from what to what?
it brings it back to the initial implementation deadline, which is what, July? July. And we wanna push it back to October, just to give them more time to develop the regs. I mean,
Well, they can't even do the training by then.
I know,
by
I
July.
understand that.
So
I mean,
it sets them up
even
for
that's
failure.
tough. Even that's tough.
Right, they can't do it.
It's a difference between doing it right and fast, so you wanna do it right and fast. Give them 3 extra months. I don't understand, so. You can't, it's just so you can't, it's not very responsible.
I don't know, I say not concur, because if we lose this whole bill, I don't know what's the big deal out of it.
Well, I don't wanna lose the bill, but,
I mean, things you went through in there, I mean, I don't know.
the Sioux conference was get the, yeah, I'd like the implementation date. Let's,
I'm not comfortable saying concur or not concur about seeing something.
We can't wait, it's a problem.
Yeah, but
You could read it on the floor.
read it on the floor?
No, I can get a reprint.
You get a reprint now?
No, I mean, they can look at it on their floor.
Oh,
Right, if they can
On
go.
your floor system, there's a button for reprints. So if you are on the top banner, you can pull up Senate Bill 763, and in that black banner, let's see, 1, 2, 3, 4, the fifth column over, you should be able to. That should be it. Yeah, that's it. It should be 843225 at the top. Let me just make sure that they didn't, right, 843225, that's the only amendment that they adopted.
So is it third reading?
Right, yeah,
It's House Bill 763.
Senate Bill 763.
Senate Bill 763.
Sorry. The only thing I would change is the implementation date, honestly, for me, but.
Does the independent investigators, do they have any authority other than police-related misconduct?
If you're looking at, if you're in
6601.
page 20 on your reprint on the floor system, if you look down at subsection C, it does provide that in C2, that IID may investigate any other crimes related to police misconduct that are discovered during an investigation. So, I mean, that branches it off. It's, I don't know whether the AG's office has interpreted that to, and that's existing law. I don't know whether the AG's office has interpreted that to apply to offenses committed by others, or people other than law enforcement, but that does sort of broaden it from just, it's broader than just the death itself.
Hey. Reprints, that's what I amended the reprint. There you go. Charles, what do you have, the whole thing, or do you have a specific concern, or?
And I'm asking because I haven't gone through with the number of changes in bills. I know there was also the issue that we were dealing with regards to internal versus external. Is that in here somewhere, or?
They kept that the same. What we
So
that's
that's been dealt with in
correct.
this?
That's the same. The only thing that is the effective date for all those changes. So they put it back to July. We had it in October.
Right.
Yeah.
Okay, if that's the case, I mean, I hear the argument with us giving them the extra time, but, I mean, it's, I guess the pushback would be it's not as if we sprang this stuff on them. I mean, this decision for the summer implementation date has been known since last session. I mean, I'd argue to just go ahead and concur, just because of the concern that we don't get anything.
The only thing is, this is kind of worth the work here, because we did set up a new statewide framework for MSP, and we did change the charging for internal, external, and we clarified things for the trial board. And so all the counties have been waiting to get clarity on a couple of those points. So now the MPTSC has to develop regulations. There's got to be a notice and comment period.
Right.
All this sort of stuff. And then they've got to do training on it. And the counties need to have that clear direction as to where to go before they move forward to final implementation. This is literally giving them 90 more days to get this figured out, which is probably not enough, but a little bit more. And so, and like I said earlier, like they've been working in earnest on this. It's not like they're messing around.
Let me ask this. If we don't concur, then I'm assuming the conference committee's efforts are going to be to deal with that one issue, the timing.
I mean, I personally like everything else except for that one piece for me.
Okay,
I mean,
thank you.
yeah. Obviously, I wanted the full prosecutorial authority, but that's, you know, it's a big bite, so. There's a motion to not concur. Is everyone okay to? Okay, okay, conference it is.
Who's gonna be on the conference committee?
Concur. And could you just explain that, what the difference is going to be? We had it pretty well sorted out, right? So that if they had multiple counties, right, we could actually find something and sort of see how it was going to do. And how is it in here now? Because on my reprint, I do not have any page numbers on here.
If you look at the top left-hand of the document reader there, it'll tell you what page out of 23.
All right, I got you now. There we go. I mean, why would you look at the actual document to see what page you're on?
Right. So if you're bottom of page 15 into page 16, it says that for sentences involving a crime of violence, include this is the report, and the information needs to be disaggregated by circuit on the number and percentage of sentencing events in each disposition category is indicated in the sentencing guidelines worksheet. The number and percentage of sentencing events that resulted in a departure from the sentencing guidelines, and for sentencing events that did result in a departure from the sentencing guidelines, the departure reason cited and the number and percentage of events in which each reason was cited. Then there's also additional language on sentencing for crimes of violence that needs to be disaggregated by circuit and crime on the average total sentence, average non-suspended sentence, and for sentences in which a portion of the sentence was suspended, the average percentage of the total sentence suspended. They also do have the data dashboard requirement that was required before, but this disaggregates by circuit, and what the amendments by the Senate had done were actually allowed for the combination, or actually, let me check on that. There was a combination that was allowed in the Senate because certain courts had, it was by county, and then certain courts only had one circuit court judge, so you allowed them to combine.
Go. You have more to say, or?
Senate Bill 860.
No, I just think, I just really do feel that the way we had done that with the judges, we would actually have a report that might be worthwhile. Going back to the circuits, we can pretty much know that right now, what's going on.
Clear here. To me, this says that I don't see why you all are saying that that division, the AG's division, does not become the lead prosecutor on this. I'm trying to understand why you're saying that. It looks to me like they sure become the lead prosecutor, and
Where are you reading, Senator?
I'm looking at the public safety article, piece 3, 527. So they provide all the evidence.
We already did not concur.
Okay.
Get clarification on why. Move on to the next non-concur.
Assessment Bill,
Or
Senate Bill
concur.
861,
Who is that?
Aid Jamie.
Man, you all shouldn't be on any conference committee, you'll never get done.
So for Senate Bill 861, this is the bill that established the State Police Gun Center. And let me pull that up. It also reclassified some offenses involving firearms as felonies instead of misdemeanors. Established a felony for theft of a handgun, and established that for certain firearms offenses, the use of a firearm does not include the mere possession of the firearm. So what the House amendments did were they struck the classification provisions. They struck the use language in the definition that use of a firearm does not include mere possession, and they struck the felony theft of a handgun. They did retain a provision of the bill that altered the state's ability to file an interlocutory appeal. They kept that. But in addition to that,
They kept one of the three.
or four, yeah.
One of the three.
In addition to that, the House amendments require that the Commissioner of Correction submit an annual report to the Secretary and Governor. They add to that annual report, and it now needs to include the annual cost of living for inmates, including the average cost of telephone calls, video calls, items available for purchase at commissary, including hygiene products, toiletries, medications, and it also needs to
They slid it in there.
the MCE reporting requirement needs to also include the race, age, and sex of inmates currently employed at facilities under the authority of MCE.
Well played. Okay, great. All right.
Obviously, the big part of this was, and what the governor wants is his crime bill. And so we've gone every year, we've been shrinking it down. Like, if the governor wanted originally a dozen things, we did most of them, but we got rid of the mandatory minimums. And then we did less the next year. And now we were down to sending 3 things over that were very common sense. And they stripped even that down and only gave us 1 back, the interlocutory appeal. I think it should go to conference because I think quite frankly, I think theft of a handgun as a felony is an easy one. But the one that's really easy and it's inexcusable, and I don't know why the House, I cannot understand why they won't close that drug dealer loophole. It's just such a terrible thing to have in our law, and I don't understand because they're holding on to that you're going to get somebody with possession of a gun and possession of a drugs and try to overcharge them, but the case law is clear, and we even spelled out the case law in there to remove the opposition. So there's no reason for them to continue to hold on to that. So I would prefer we conference it.
Thank you. A question and a comment. And I don't recall if I missed this or not, but when we sent this over, did the bill have an interlocutory appeal in it? Second thing, I know Senator Carter, I think she had mentioned that she had submitted a request for an amendment to have her name stricken from the bill. From it, I don't, and I'm just making certain that you all are aware of that, so that I think when I had spoken with her before, she said she had the amendments drafted, so I don't know if that's something that she would be, or how one goes about putting that on. But yeah, so that's it.
Well, if you want to contact Senator Carter, maybe we can clarify that, but are you all in receipt of those amendments? Is anyone, council?
I haven't seen them.
We'll make sure we get them right, though, if she,
I mean,
yeah.
that would be something that they work out in the conference committee
Okay.
report.
We can put it in the conference committee report.
Yeah, I think it's just taking her name.
Got it. All right, so the motion is not concur. Second. Is anyone opposed? Okay. Oh, let me figure it out. in a second.
Which is Josh.
568 is next.
586.
586.
Oh, that's Jamie. I'm just kidding.
All right, Senate Bill 536, Real Property Actions to Repossess, Judgment for Tenants, and Proof of Residential Licensure. The amendments adopted by the House made a technical correction. They struck the term review and substituted the term renew.
Has been a development in the last 3 or 4 days. At the moment, I believe still, all of the advocates are sitting in my office upstairs negotiating another amendment that could be added by the conferees to deal with a rarely occurring situation, but they're concerned about it. So Matt Hill is up there with Ann Seacott, and Kathy Howard is up there with Grayson Wiggins. I think Bob Enton is somewhere in the vicinity. They're trying to come to consensus on an amendment to deal with this small problem. And my thought is, if they can come to consensus, and we have a conference committee, the conference committee could add to both bills, the House and the Senate bills, the consensus language, and we can go forward.
Yeah, go ahead, do that, and then.
So what's been discussed with me, the issue is if a landlord has 2 or more properties under the same license, one unit is no longer in compliance. It's
One unit in the building is not in compliance.
correct. So if a landlord has more than one unit under the same license, one of the units is out of compliance, and the landlord is not renting it, has no interest in renting it, or for whatever reason, it's out of compliance. The landlord wants to evict tenant in a unrelated unit that falls under the same license. If the landlord during that time period loses his license for the unrepaired unit, the landlord would not be able to evict a tenant for failure to pay rent under that license. That also tracks with current common law, McDaniel v. Bernowski, a 2011 case from the Maryland Court of Appeals that held that a landlord is not entitled to use statutory remedies upon a tenant's failure to pay rent if the landlord has not complied with applicable residential licensing requirements. So the bill tracks current common law. So, and that's a 2011 case law. So I'm not saying that issue isn't possible, but the bill is with current law, common law.
Right, but they're trying to fix this problem. I have a draft of, which I won't read, of 2 sentences to add as an amendment, which the landlords believe would fix the problem, and I think they're all discussing it with Ann Seacott and Matt Hill up in my office right now. So could we maybe move this to the end of this voting calendar? And hopefully by that point, we will get some word from my office about whether they've reached agreement on this?
I would ask that we not do that. I mean, the clock is ticking. This has been around for a while. I would ask that we not,
We're just
that
talking
we
about moving it
concur.
to the end of this voting session.
I wanna
Instead of
make-
voting now, wait for
I-
40 minutes.
well, aren't we supposed,
They're supposed to be on the floor at noon?
Out, so, okay, if, we are voting something out on this, I mean, this time, because if not, this, it's gonna, it's gonna die. So, even, let's say Matt Hill, all those folks get together, they come up with something, what's the game plan? It would go to conference and then both would be adopted and go through, or what's the?
What I learned a couple years ago is the conference can bring back language which was never in either bill. So
no,
that,
there's no two bills, there's only one bill.
okay, so in this case, it's just one bill. So the conference can bring back language that wasn't in the bill. So everybody would agree by consensus on this one amendment. You go to conference, they would adopt the one amendment and bring it back to each house as a part of the concurrence, or whatever.
Then it goes to conference, and then it needs to be adopted.
Yeah, so after the conference committee, if they adopted an amendment, then it would go straight to the floor, not back to committee. But
Advocates who are not making any headway.
Is that right? I was
That's-
going to suggest let me call them and find out.
You can call them, but that's what I have heard, and I would press
If
to
they're
do
not making
this.
any headway, they would just go ahead.
Okay. Right.
All right, so we do a roll call on the concur, not concur, the motion's for favorable to concur, the motion's to concur. It's been seconded, we can do a roll call.
Vice Chair Wabstricker.
Yes.
Senator Lee. Senator Castley.
Pass.
Mike, where's Senator Lee?
Senator Huddleman.
Yes.
I'm sorry?
Voting,
Senator West.
voting on the not to concur, you don't have the votes.
Yeah, I understand. Let me pass this first round. Sorry.
Senator Sidnor.
Yes.
Senator Watson.
Pass.
Senator Bailey.
No.
Well, hold up. I'm excusing Carter. Senator Huff.
No.
Senator Lee.
You get your amendments.
Is this to,
This is to concur.
yes.
Senator Castley.
No.
Senator West.
No.
Senator Watson.
No.
Conference.
Chairman Smith.
Yes. Can you call Senator Carter, please? Can someone call her?
Just had a vote, it's done.
I know it's done, I know that's done, but
Next item, that one's going to conference.
So this is the Courts and Criminal Justice in Baltimore City bill that the Senate passed. This has this is Senate. Senate Bill 586. And again, if you go to the reprints tab on your floor system and pull up the third reader amendments, this will have it. This has the notification by DPSCS to BPD when an individual is released. That still needs to happen within 24 hours of the release, and it needs to be provided in a manner that allows the sorting and filtering of information provided by DPSCS. It also includes the Jobs Corps pilot program and includes a provision on firearms reporting by BPD. So those provisions are the same. The only thing that was changed is actually this makes it consistent with the other Jobs Corps bill that was passed out by the Senate the other day. It goes until 2028. There's an appropriation of $500,000 to the Baltimore Workforce Development Board each year that it's in effect. So that this really just makes the House amendments make it consistent with what the Senate just passed out.
Yeah.
The Senate passed this bill 47 to nothing.
But I thought we just passed a separate jobs bill.
And as long as they're identical,
Identical, okay.
there's no issue.
Okay.
Did the House change our bill that we passed?
To conform with what the Senate just passed last week with the
Okay.
Jobs Corps bill.
So, it would,
So concur, right?
so concur.
Everyone good?
Right, yeah.
So there's a motion to concur, everyone's good? Excellent.
As amended by the House, the bill authorizes Department of Human Resources of Carroll County to request a criminal history records check for a prospective county employee or volunteer. The amendment limits this to persons assigned to certain positions or a position that involves care or supervision of a minor. This is a Carroll County Senator's bill. The senators are in favor of the amendment. So recommendation would be concur if you want to do that.
465 vehicle laws, licenses and permits, prohibitive acts. Josh.
So as passed by the Senate, this bill repeals a catch-all provision which prohibits a person from doing any act forbidden by or failing to do any act required by Title 16 of the Transportation Article, which governs licenses to drive. The House amendments replace that provision with a prohibition on engaging in any fraudulent or dishonest conduct in the examination or testing process for the issuance or renewal of a license or permit. That Senate has already passed the House cross-file with this amendment, so I would recommend concurring to be consistent.
Everyone's all right? All right.
Senate Bill 731. Josh. Vehicle towing and removal secured parties electronic.
So as passed by the Senate, this bill requires a person who tows a vehicle from a parking lot to notify a secured party electronically if that form of notice is agreed to by the tower and the secured party. The House amendments clarified the language in the bill. The Senate already passed the House cross-file with the amendment, so I'd recommend concurring.
SB 642. Josh. Crawford County vehicle height monitoring systems.
So as passed by the Senate, the bill authorizes the use of vehicle height monitoring systems in Hartford County, subject to requirements that are similar in other jurisdictions. The House amendments made the bill an emergency bill.
All right. Senate Bill 432. Baltimore County Orphans Court judges and surviving spouse suspension.
I don't think I handled that one, Heather.
Thank you. So Senate Bill 432, Baltimore County Orphans Court judges and surviving spouses pensions. The amendments adopted by the House place the Senate bill in the same posture as the House bill as passed by the Senate unanimously. That was the House bill. This is the Senate bill.
House Bill 73 expressly authorizes Baltimore City to use fines collected by the city as a result of violations from specified automated traffic enforcement systems to be used to administer the systems, and any remaining funds to be used for infrastructure and non-infrastructure activities eligible for funding under SHA's Safe Routes to School program and public safety or transportation infrastructure improvements consistent with the purpose and goals of the State Complete Streets program and the city's Complete Streets program, and also requires that the Department of Transportation's annual Complete Streets program report be sent to the Baltimore City delegation.
That's the original bill. Yeah, is this a concur, non-concur? What is this? This is the bill.
This is a House bill we have.
Oh. So I'm just going to throw out that normally we limit what you can use these funds for so to disincentivize jurisdictions from using automated systems to basically fund their entire infrastructure. And this reverses that, because if you just have the funds are used to administer that fund, then there's a disincentivization to, it disincentivizes using these automated things in an improper or overly zealous manner. And so now you're saying, no, you can take this and use it as zealously as you want. You can fund road improvements, bike improvements, everything, have at it. I think that's a really bad way to go. It's a break with what we've done in the past.
So I believe the current law simply says roadway improvements, and this is a little bit more specific, although I'm not clear on it, all of the various programs that are included under this.
Transportation infrastructure improvements consistent with the purpose and goals of the Complete Streets program under section 8903 of the transportation article. Do you know what that is?
I'm not aware of all of the programs that covers now.
Whatever. Yeah.
We do have the.
And we have a delegation letter. All right, Senator from Baltimore City and Baltimore County. You want to speak on it?
Yes, I move favorable.
Vice Chair Wellstreaker.
Yes.
Oh. Okay, Senator Lee. Senator Castley.
No?
Senator Heddleman.
Yes.
Senator West.
It's a local bill?
Yes.
Yes.
Senator Sidnor.
Yes.
Senator Watson.
Yes.
Senator Bailey.
No.
Senator Huff.
No.
Chairman Smith.
Yes. Bill passes. All right, now we'll go on to Heather with House Bill 1448.
So House Bill 1448, this bill establishes that a county or Baltimore City has concurrent civil jurisdiction with the district court to adjudicate violations of certain local ordinances. So these are things like housing and building fines, nuisance fines, zoning fines, sanitary sewage fines.
In this letting district, or is it the other way around?
So currently, the district court has jurisdiction, so this would do concurrent with like the local administrative proceeding and district court, which mirrors the way things were practicing until a recent Court of Appeals case said you can't do that under current law. So this would take it back to the way things were operating until a year or two ago.
Passed the House, 135 to nothing.
Okay.
And
That's
I'm told there's no opposition.
I mean, it's great, but like that means zero in this room. All right, motion for favorable, unless there's further discussion. Second, everyone's good? All right. Josh, we'll come to you, House Bill 559.
House Bill 559 essentially creates a new procedure for a probation before judgment by authorizing a court to place a defendant on probation if the court finds facts justifying a finding of guilt and makes corresponding statutory changes and establishes procedures for this. Essentially, the issue the bill is looking to solve is that probation before judgment is not a conviction for the purposes of state law, but for certain federal definitions like immigration and some kinds of military employment, our current statute falls under the definition of conviction. So the idea is to create an alternative procedure which would not trigger that definition. There is an amendment in your packet, which is essentially all this amendment does is it includes a requirement that in order for a court to grant this kind of disposition, the state's attorney has to agree to it.
So let's discuss the bill first, and then we'll talk about the amendment. Senator Castley.
This, first of all, why are we changing, there's 6220B, the amendment that says, why are we amending that section and also we're amending B1 and B2. Why would we do both of them? Because we're saying even on the standard PBJ, that or a court finds facts justifying a finding of guilt. Why don't we just proceed under 2? And can somebody explain that? Why do we amend 1 and 2 both?
So the way that I read it, B1 is essentially authorizing the procedure of probation before judgment, and then B2, so it's saying, when a defendant, pleads guilty, nolo, or court finds facts, the court may stay the entering of judgment, et cetera, which is the probation before judgment procedure. And then B2 creates certain rules around that, which is now, with the amendment, that's becoming B3. But it's saying subject to these subparagraphs, when a defendant pleads guilty or nolo, or the court finds facts. So essentially, B1 is creating the procedure of probation before judgment, and then B2, which with the amendment becomes B3, is essentially laying out the specific procedural rules of the probation before judgment.
Okay, so you go into court. So the state's attorney could say, I'm not going to proceed on, or a court finds facts, I'm not going to consent to the PBJ under that. I want a finding of guilt and proceed in that fashion, or I will agree, because it looks like if you do, or a court finds facts justifying that it has to have the state's attorney's consent if we're under or a court finds facts justifying, right?
Correct. With the amendment, that would be, you would need the state's attorney's consent to have that procedure.
Okay, so if the Court of Appeals strikes down this, the courts had trouble with this whole thing because whether the court can actually just simply find facts and then take action without entering a judgment of guilt. So if the court could find this unconstitutional, just strike that provision, and we wouldn't screw up our PBJ law, right?
Yeah, I believe they could basically strike the new
Yeah,
provisions being
excise that
added in the
piece.
bill.
Okay.
So I believe in 2020, the bill passed out of the Senate, or at least out of the committee, but it didn't make it all the way through.
The only person who can appeal it isn't going to appeal it, right? So they can do it. Yeah. Okay. Hey.
And just to clarify, the constitutional issue would likely arise in the scenario where, you do this procedure, the court finds facts, there's no guilty judgment or guilty plea, and then the defendant later violates probation, comes in, the court finds that there was a violation of probation, proceeds to sentencing on the underlying crime. And so the argument would be, in the absence of the judgment or a guilty plea, you couldn't constitutionally move to sentencing. And that's, I think, generally kind of an open question on which there's no real good answer at this point.
But the current version of the bill requires an agreement upfront by the defendant, so the defendant is well aware. that-
Right. It requires the defendant to agree to that procedure and to waive trial rights.
Bill, right?
Right, that's explicit in the bill.
Okay.
So you're sort of merging PBJ with the stat docket, right?
Essentially.
I mean, because, right? I mean, if there's a violation, it's basically like a stat docket violation.
That's true.
It is exactly that, but at least now.
Can't trigger restitution or community service. You can?
You can make it conditional.
Okay.
All for anything, right?
For a period of time.
3 years.
Yeah. Usually after a year, it's for good cause shown to the court, but for the first year, it's usually any reason, usually.
Yeah.
But you can make them conditional, because you can say that if you don't do the I've done that. You can do the restitution, then it's gonna come back and be prosecuted. So technically, that's already,
In practice, yeah. Got it. The motion's favorable with the amendment.
We have to adopt the amendments first.
You want to adopt the amendment? Everyone's okay to adopt the amendment? Motion's favorable with the amendment? Senator Lee moves favorable. Can you put her on the mic, please?
Can you also change, okay, can you also do this for SB 265?
Yeah, we'll do it next.
Both of them, okay? Make them identical, thank you.
Senator Kessler?
Yeah, but even, Jill, even under a stat docket, they actually don't have to have another trial, right? If you violate the terms of the stat, they don't come back and have a trial on the underlying crime.
conditional step, and the person doesn't comply with the condition, they just come back and prosecute late, the person is given up the right to a speedy trial.
Right.
They still can be tried.
But you have to do a guilty finding, even on this, I mean, you put it on the stat docket, you violate the terms. Now you come back into court, right? And now is there a trial on the underlying, so there has to be a finding of guilt on the underlying crime. Right. And and it could either be by a statement of fact, or if the defendant doesn't agree, then you'd have to put on a trial. So in this case, under this, which is sort of like a quasi-stat, you're gonna have to, you violated this, now it comes back, the prosecutor's gonna have to put on evidence. They're gonna have to say, let's bring the police officer and whoever the witness is and put on the trial, right?
I would think technically that would be correct.
Well-
This bill creates a different process where the defendant is up front saying they're giving up that right to the trial.
Right, so on page 3 of the reprint there, part of the agreement is that the defendant agrees that the court may find the defendant guilty of the underlying crime as a result of the violation of probation. And that is where the potential constitutional issue comes into play, although the answer to that is, that you've waived those rights in the agreement.
I mean, this is gonna go down in the Court of Appeal, ultimately. I mean, we can, hey, creative writing is fine, but ultimate? Okay.
90s in Virginia, they amended their bill.
I'm fairly certain at some point, once we pass this, a defendant is going to challenge it, and then it'll be an issue for the courts.
That is 100% correct, but.
How quickly they violate, right?
All right, well, let's take a good try, the good college try. We'll see what happens. All right, so is everyone okay with the bill as amended before you? All right. Passes unanimously. So now we're going to bring up the Senate Bill
265.
265. We're going to adopt the same amendment
So you're gonna conform it to
and
the House.
conform it to the House version. Is everyone okay with that? 265, it's the Senate cross-file.
Oh, wait, I wanna be no on both of these.
Okay,
I can know on this one and know on this
yeah,
All right, who's a no on them?
all right.
Huff? Huff is a no.
Huff's a no on both. All right, Cassidy's a no on both. Senator West
Sandy, could I have a no on these two bills?
and Senator, and Bailey's down on all four. All right, what? All right. Once was unanimous, is now party line vote. Go ahead, Senator West.
Senate Bill 563, that's the one about landlord licensing. I'm informed that the conferees were not able to reach agreement. Therefore, I think we should go ahead and proceed with to concur in.
So there's a, hold on, let's.
Okay, fine. Yeah, I see. Now, I think we're going to do the right thing, which is to concur and get this passed.
House Bill 406.
So House Bill 406 was jointly assigned with B&T, so B&T was primary, they had it first. So there's an amendment in your packet, which is what I recommend looking at. And so that's the amendment ending in 925. So there are three separate. This is House Bill 406, Children in Out-of-Home Placements, Placement in Medical Facilities.
We never even voted on this bill. This is a new one up, right?
Yeah, we have not voted on this, so the amendment in your packet is what B&T sent us. So there are three separate parts of this bill. So going from the end of the bill forward, first there is new amendment from B&T language, which adds explanations for how certain funding that already is in existence to be spent, and a reporting requirement. There's also a task force. This is on page 10 of the reprint. And then there is the substantive parts of the bill. So beginning on page 3 of the bill, it goes through new procedures for the commitment of a SINA child. It also, on page 5 of the bill, requires DHS or Department of Human Services to provide certain information to any hospital or facility that is caring for a SINA child during commitment. It also requires DHS to adhere to a placement planning timeline. It provides liability for Maryland Department of Health that fails to, they are subject to any administrative or legal proceeding brought by an aggrieved party. And it also provides language for how a facility who is holding these out-of-home placement children, the SINA children, how they can submit requests for payment, and then also requiring them to report certain information about the children to DHS.
Money that is attached to this?
So if you look at page 12 of the reprint, section 3, so the governor's, the supplemental budget number 4 contains $15 million. So this specifies that will be to assist with the placement of difficult-to-place youth in residential treatment centers to be used to address the issue of hospital overstays for youth in state custody, particularly those with psychiatric needs. So this is not affecting that. It's providing clarifying additional language for how that money should be spent.
Are we second on this bill, or what are we?
We are secondary.
So I just like, I have been working on this a little bit because of this exact issue of somebody from Baltimore County who is being, I don't know, held is not the right word, but is in a hospital in Montgomery County. And it is just an abhorrent situation. It is horrible that this is what's happening to this child, and I know it's happening repeatedly around the state. And part of it is because there are not enough services for kids who need this kind of behavioral health treatment, and the number of treatment facilities, treatment placements has been reduced over the past many years. And so if this is going to take important steps going forward to expand the kind of services that these really difficult to, address children's needs are, then I am wholeheartedly for it. It's not all that we need, but I do feel like it is a step in the right direction. And there just needs to be better coordination between the department, between the local, the Department of Health, the local departments, and we need to be able to step up and give the resources to be able to address the need, the very real and serious needs that these kids have.
No, I agree with you 150%, but I just want to make sure that there's a place for folks to go to get those services when they're released. So that's the number one thing.
Absolutely.
Senator Huff.
Did we even have a hearing on this? Or we just sent 2 committee members up to B&T?
We sent Castley up, I think. Senator Castley went.
So my concern is, I understand what you're saying, but if there's no money attached, I'm looking, it is, how much?
15 million?
How much, 50 or 15?
15, 1, 5. Yeah, it's in supplemental budget number 4.
I mean, my concern is you've got the judiciary, you've got, and then the letter from GoCap, and I thought there was one in here from the Department of Health, and then the mental health folks. I mean, it seems to me that if you're limiting, these are kids that are having serious psychological issues, maybe threatening to commit suicide, schizophrenia, very serious. They need to be someplace. And the concern, at least, I'm trying to read this real quick because we didn't have a full hearing on it, but I'd heard about this bill a little. The concern that I'm hearing or looking at some of the testimony is these kids may just end up back at home, which would be the worst outcome. So as bad as being at a hospital or someplace else can be, the worst possible outcome is they end up back at home. And I'm trying to make sure, is that going to happen if we pass this?
That was my question. Like, so the proper facilities. I know there's $15 million attached, but how? That's the timing is what I would like to know about. How soon can that happen? But Senator Castley, go ahead.
Yeah, so I was our designee to sit in on the hearing on this one, and the issue that I found most troubling, which is still in here, is page 3 of the bill, and it says between lines 11 and 31. Basically, this is you'd have a court hearing under the circuit court, and they hear evidence and they decide that we need to have an admission, but then they can't issue an admission under line 25 if an administrative law judge has made a determination that the child does not require such treatment. So it's really, this is the only place I know in the entire annals of Maryland law that administrative law judge trumps, a decision of an administrative law judge trumps a decision by a circuit court judge, which is, circuit court judge could have heard a week's worth of detailed testimony about this kid and all the details about it, and you have an administrative law judge who hears an hour's worth of testimony, limited testimony. The ALJ says, no, it shouldn't be admitted, and the circuit court judge says, no, wait, now there's no place to go, all these kind of problems, I want admission. Sorry, there was an ALJ that said that.
That's exactly, the judiciary testimony
Yeah.
is exactly that. The
Yeah,
judiciary
it's-
remains opposed to provisions of the bill that pertain to the administrative law judge, which are not amended. The bill states that the court may not commit a child for inpatient psychiatric care if an ALJ has made a determination that child does not require such treatment. This limits the court's discretion, so on and so forth.
Yeah, so you could have a circuit court that heard all kind of professional testimony for, lengthy, and then an ALJ steps in and says, no, what I heard says no, right? And so, now this does say it has to be the same testimony, but you still have an ALJ, they're not approved. Circuit court judges are different because they're nominated by the governor, they're advice and consent of the Senate, they're approved, they're subject to recall, their voters' approval, and ALJ gets none of that. ALJs are appointed, they don't do us on anything, and so it's giving super deference to an ALJ over a circuit court judge. I just find that really troubling in our system.
So I did speak with individuals at the, from OPD. The way it was explained is that during the commitment process for an individual who's not SINA, they could go before an ALJ to determine whether the individual should be committed or not. And for purposes of appeal, that is a final decision, which then can go to circuit court for appeal. However, with CINA, because there's a separate CINA court process, so the child would go before the ALJ. The ALJ, based on the information, will make a decision. That's a final decision which could be appealed. But that decision isn't being appealed. Instead, what Maryland Department of Health is then going before the CINA, for a CINA hearing based on, and then presenting evidence for the commitment of the child. What this bill does is it closes the ability to get the final ALJ decision, and then instead of appealing that, going before the circuit court for the CINA hearing. And it says, as long as the information's the same exact information, there's nothing new, you can't do that. Yeah.
Just deny the appeal. I mean, that's crazy to say, well, yeah, you have an appeal, but it won't matter. If that's our intent here, is to say it's not an appealable decision, the bill should have said it's not an appealable decision. But say, no, you can appeal it, but he's bound by their testimony. The ALJ's decision just seems like a crazy way to do that.
If you don't have it set up, what are you really creating? It's kind of sad. We should just give them the funding and strip the bill.
Well, the problem.
You can't force these kids.
School. They're sitting literally not being admitted to the
Better a
hospital.
hospital than nowhere. If you're having a schizophrenic breakdown or about to commit depression
No, I
or
agree, but they're
suicide.
not getting the psychiatric treatment when they're there. In this situation.
Well,
And
then
you're-
we should
And they're holding
send,
a place for a kid who does need the psychiatric.
well, then just send the money, then come back next year and expedite removing him out of the hospital. I just can't, how can you in good conscience do it law to expedite removing him faster when you haven't put the money there first? Or delay the effective date on the bill like a year or something. You got to put the money first, 'cause if a kid's trying to kill himself, how can you in good conscience just send him home?
But that's not, my understanding is that the immediate emergency has passed and they're just languishing there. For immediate psychiatric treatment, I 100% agree with you.
It's
They
not-
should be in
it's
the
not accurate. So
hospital.
what the
But it's
hospital-
beyond that.
What the hospitals
in
want,
their
the hospitals love, and a hospital's only equipped to hold somebody for 48 or 72 hours, just to stabilize you, and that's it. But, once they've stabilized you, you are in no condition just to go home.
I agree.
Like, and you need to go someplace. And if there's not someplace to send you, then you should not go home. And even though a hospital is not ideal, not the best, Shelley, it's very worrisome to talk about sending these kids when we don't have facilities. And this bill should have come to us, by the way. This was,
No,
again, a bad placement that this went to B&T. B&T doesn't deal with these things. They just deal with the money. I understand that.
They supported it. And you look at the number of
So
organizations.
just to be clear, I agree with the money and I agree with the sentiment of the bill. I'm just nervous, and that's what I said about the timing is, so we cut this off, where do the kids go now? That's what I want, that's all I wanted. I mean, because I agree with everything you said, 150%, but.
And they're medically cleared, so they're just sitting there. Like,
Only medically cleared for the 72 or 48 hours. So, for example, if you're schizophrenic or bipolar or having a serious mental problem, they're just going to stabilize you enough to get you out of the hospital. But whatever the underlying issues, they still exist, and they need treatment. And so,
I agree with you.
what we could do is do the funding now and push the effective date back on the bill at least a year. There's just no way in good conscience that you should send the money out and then put the bill in effect right away. I don't even know if $15 million is even enough to even address this. This is such a massive problem right now in society and everything else. I mean, I don't even know if that's like a drop in the bucket. You could build up one facility in like Frederick County for that. Not even, probably. This is the old cart before the horse.
Why in the world was this bill assigned to B&T as the partner? It should have been assigned to us. And we should have heard testimony weeks ago.
I don't disagree.
And worked on this.
See, now, no,
It's a big issue.
Testimony now.
Let's table this until the next time we come back to vote.
All right.
And please do the research, while there's some spare time on the floor, just dig in on this. And if you need information from counsel or advocates or whomever, let us know, and we'll make sure you get it. On the floor, I'd like to do, I think, if we could do Senator Wallstreicher. Senate Bill 653.
Senate Bill 653 expands mandatory participation in the ignition interlock system as drafted to an individual who is granted a PBJ for driving under the influence, and an individual convicted or granted a PBJ for driving while impaired by alcohol. There's an amendment in your packet that's number 983828/1. So this would limit the extension of mandatory participation to people who are granted a probation before judgment for driving under the influence of alcohol. But it would also give the court the ability to waive that mandatory participation if it finds that the participation is not necessary for the safety of the community. And finally, it would require the MVA to provide information on fee waivers, and require that if the MVA grants a fee waiver, they must also make the defendant eligible for waivers of installation, removal, and rental fees for ignition interlock devices.
Just a. All right, so it's
So-
favorable.
Adopt the amendment.
The amendment's been adopted, and there's been a motion for favorable on the bill as amended. It's unanimous. All right. Sorry, go ahead. Senator Sidnor.
So again, these are people who still have to have a PBJ, and we're putting these.
Seven, six.
So House Bill 176, courts service of process fees collected by a sheriff. So this bill increases from $40 to $60 the fees that a sheriff must generally collect for certain processes. For example, service process for paper not including the execution of attachment, for service of process, papers arising out of administrative agency proceedings where the party requesting the service is a non-governmental entity. There were amendments adopted in the House which addressed the unfavorable or favorable with amendments testimony. And the last increase to this section was 15 years ago.
I can't make this any louder.
Bells are ringing. All right, so.
I thought it was 12:30.
12. All right. All right. Move favorable. It's been seconded. Do we need a roll call? Is everyone okay? All right, great. That's passed. Senator Cassidy's down.
Put me down on it.
Huff is down. Bailey's down. Everyone else is good. West is up. We did interlock. Yeah. It's,
Yes,
interlock.
it's been
Yeah,
recorded.
it's been recorded.
Bailey's up.
I know, Bailey's up,
up.
sorry, Bailey's up, sorry. All right, last thing we're doing before we go, we have to, a motion, so what is
Motion
it?
to reconsider.
House Bill,
Senate Bill 563.
Senate Bill 563, there is a motion to reconsider the vote. Second. Okay. That's fine. Motion to concur. Do we need a roll call, or is everyone fine? So, that's the rent, yeah, it's the one Wes is working on. Okay, so it passes unanimously then. Okay, we're done. See you on the floor.
Hey, Mr. Chair, did you guys? I've been trying to catch this bill because I knew the House amended it. 861, the gun. Is it on the floor? What's the process?
So it just goes to concur. We can't amend it. It's just to concur, not concur. It would be up to the conference committee to make any changes to the bill.
Okay, who's on the conference committee?